Hello and welcome. I'm Chakshu Roy and you're watching Laws in the Making on Rajya Sabha TV. Today we bring to you the Specific Relief Amendment Bill 2018. The bill seeks to restrict discretionary powers of the court in granting specific performance of contracts. To discuss the issue, I have with me Mr. Vivek Goyal, Advocate of the Supreme Court, and Ms. Roshini, Sinha, Analyst at PRS Legislative Research. But before we get into a discussion, let's have a look at what all is there in this proposed legislation. The Specific Relief Amendment Bill of 2018 ensures performance of contracts, be it building large bridges or small individual establishments. The bill intends to wean the courts away from the usual practice of closing a case after just granting monetary damages to the injured party to the contract. Instead, it pushes courts to direct parties to complete a project agreed to in the contract.
The Specific Relief Amendment Bill 2018 seeks to restrict discretionary powers of the courts in granting specific performance of contracts. It also seeks to make specific performance a general rule rather than an exception, subject to a few limitations. The bill provides for third parties to be allowed as a substitute if a contract is breached. Aggrieved parties need to give a 30-day notice seeking specific performance of the contract. If the other party does not perform its obligations, the aggrieved party will have the right to perform the contract itself or through a third party. If the aggrieved party benefits from substitute performance, its right to seek specific performance against the party will be closed. The aggrieved party will be entitled to recover costs relating to substitute performance from the other party.
The specific relief law is in relation to when two parties contract. The party should have ability to enforce what has been agreed upon by one party or the other party in the contract. That's a law. So far as this bill is concerned, I think as you know, for making any amendment in law, it has a parliamentary processes to be carried out. So this bill has been introduced to carry out certain amendments in the Act to make it more modern in a sense that where the enforcement is more important than the money compensation claim which the courts are generally awarding in lieu of the specific performance. I think to take care of a situation that the contracts are enforced properly and more in case of infrastructure contracts, I think that's the bill specifically deal with this aspect.
Under the Specific Relief Act 1963, courts award monetary compensation, and it is only under exceptional circumstances that they direct the completion of work under contract. But even though compensation is awarded, it doesn't solve the problem in case the work is delayed or remains incomplete. The Specific Relief Amendment Bill addresses the issue in four ways. It makes completion of contract a method of providing relief instead of simply giving monetary compensation. Second, it provides that the party whose work has been incomplete can get it completed by another company or do it themselves. In such a case, it can recover the expenses from the party that left the work unfinished. Third, the bill emphasizes infrastructure projects relating to transport, energy, water and sanitation, communication, and social and commercial infrastructure. Lastly, it says special court will hear disputes relating to these infrastructure projects.
Government wants to change this law to cope up with all those transactions like just foreign direct investment. There are plenty of the new commercial transactions takes place. There are the new investors coming to the India. So all those contracts takes place. If the new contracts takes place, there were no earlier in the Act, there were no policy to tackle with all those issues.
To deal with infrastructure projects, the bill allows state government to designate civil courts as special courts in consultation with the Chief Justice of High Court. Cases must be disposed of within a year of the defendant receiving summons. Courts can extend this period for 6 more months. Finally, the bill provides that courts hearing disputes under the Specific Relief Act can get opinion on specific issues by engaging experts.
The Specific Relief Amendment Bill is a technical piece of legislation. It will have impact not only on contracts but also the economic situation in the country. And to discuss that, let me start with you, Vivek, first. What is the context in which this bill has come to Parliament? Can you talk a little bit about that?
Yeah, you know that India is a developing nation, and now in near future we are going to be the 5th largest economy of the world. And this this act was enacted in 1963, the Specific Relief Act, And after that, there were no amendments taken place in this act. And in 2016, the government has appointed a committee to think and give its recommendation regarding the amendment to the Specific Relief Act. And in November, this report came in November 16, and after that work was done on this, and this bill was enacted, put before the parliament. Lok Sabha has already passed this bill. So the basic amendments which this bill is seeking, one, they are giving a category, specific category of infrastructure, and they are reducing the time frame, giving a specific time frame of 12 months, and which can at maximum increase to 18 months. So it will help the overall business scenario and the economic development of the country. If you go into the history of India, India was the largest economy of the world for a longer period of entire history. And if we have to reach that stage, we have to remove all the hurdles before the
and
India's
enforceability
business.
of contract
And
is one of those hurdles.
yes.
Roshini, let me come to you. So why do you think, what are the important parts of this bill? Why is this bill important for it to come before Parliament, and what are the different things that you see in this bill which needs to be highlighted?
Sure. I'll first discuss some of the more important provisions, that this bill is introducing. And to just give context, this bill amends a principle of 1963. And what the 1963 Act looked to do was to provide remedies to a party whose contract has not been performed. Now, broadly, these remedies was the remedy of specific performance, where the party could ask the court to ask the other party to perform its bargain, or it could ask for monetary compensation. Now, under the principle of 1963, specific performance was a limited right, and it was given by way of exception, while monetary compensation was the general rule. Now, one of the major changes that this bill brings about is to flip that rule and make specific performance the rule rather than the exception, and to grant monetary compensation in limited circumstances.
But why is that important? I mean, you are getting money in return if your contract is breached. So why is it so important to get a contract enforced?
Sure. So, just to talk about what are the kind of contracts that come under the purview of the Specific Relief Act, these are largely a lot of important infrastructure contracts. There may be public-private partnership contracts, large development contracts. One of the issues that is often discussed are delays in the ability to enforce these contracts, to perform these contracts. With monetary compensation as the rule, there is an element of a time cost in going out and finding then a third party to perform that contract. Sometimes parties are not adequately compensated by merely monetary compensation and require a contract to be performed in a timely manner. So it's important from that perspective that specific performance has been made the general rule rather than the exception, to in some sense compel parties to perform the contract. Another aspect to think about is, that the World Bank releases an annual ease of doing business rankings, where India has jumped from 130 to 100 in 2017. But one of the parameters on which ease of doing business is judged is on the ease of enforcement of contracts. And there, the report showed that when it comes to India, it takes an average of 4 years for a case to be resolved in a court, while in, say, Singapore, it takes all of 6 months for a case to be resolved. So there was a changing legal and economic context, because of which there were certain changes that had to be brought about by the bill, and the bill is looking to introduce these certain changes.
Vivek, and the last time the two of us were together on this show, we were discussing some of these issues, and you practice extensively in the courts. How significant are these delays when it comes to contracts of specific release or cases of specific relief? Do they take a long time to resolve?
Yes, normally cases do take a long time, but gradually things are improving. Earlier, as if we go into 10-20 years back, cases used to take maybe 10 years, 20 years. We have seen cases who had took more than 50 years also to be resolved ultimately in the Supreme Court. But now the things are improving and results are coming much faster, and courts are even deciding instantly in some cases, and things are improving, and that is good for the business as well as for overall economic scenario in the country. That's
Roshini, before we head into a break, what is that one provision in the bill do you think that could help speed up or assist the courts in dealing with technical matters that come under the Specific Relief Act?
So one of the changes that has been brought about by the bill is to allow for the appointment of technical experts to assist the bench in dealing with matters where the judges do not have technical expertise. So that can go a long way in understanding the nuances of matters that involve large technical contracts and help resolve them faster.
Okay. It's time for us to head into a break. When we come back, we will tell you about the legislative journey of the Specific Relief Act of 1963. Welcome back. Based on the principle of equity, the Specific Relief Act of 1963 is used to grant specific relief for enforcing rights in civil proceedings. In case of breach of contract, the general remedy available to the aggrieved party is compensation or damages for loss suffered.
The Specific Relief Act 1963 sets out the remedies available to parties whose contractual or civil rights have been violated. The Act provides two main remedies for parties whose contract has not been performed. Firstly, it could ask the court to compel the performance of contract, and secondly, it could seek monetary compensation instead of the performance.
हमें एक कमेटी अपॉइंट की थी मिनिस्ट्री ऑफ फाइनेंस ने, मिनिस्ट्री ऑफ लॉ ने, जनवरी 2016 में, और उनकी टर्म्स ऑफ रेफरेंस स्पेसिफिकली ये थी कि किस तरीके से एनफोर्समेंट ऑफ कॉन्ट्रैक्ट को प्राइमरी रूल बनाया जाए कि जब आपने ज़बान दी है, आपने कॉन्ट्रैक्ट एंटर किया है, तो आपके जो प्रॉमिस थे, ऑब्लिगेशंस थे, वो आप परफॉर्म करोगे। अगर किसी कारण कचहरी को लगता है कि आप नहीं कर सकते, जिसमें आपका दोष नहीं है, तब कॉम्पनसेशन होगा। आज रूल उल्टा है। तो उस कमेटी को ये क्लियर इंस्ट्रक्शंस थे। दूसरा इंस्ट्रक्शन ये थे कि 1995-2000 के बाद इंडिया में इंफ्रास्ट्रक्चर डेवलपमेंट, खासकर 2005 के बाद प्राइवेट सेक्टर का मेजर पार्टिसिपेशन हुआ है।
The Specific Relief Act 1963 was enacted to define and amend the law relating to certain kinds of specific relief. Among other things, it contains provisions for the specific performance of contracts or contracts that are not specifically enforceable, parties who may obtain and against whom specific performance may be obtained. It also gives wide discretionary powers to the courts to decree specific performance and to refuse injunction. As a result of wide discretionary powers, the courts in majority of cases award damages as a general rule and grant specific performance as an exception.
20A is again, because as I said that there are certain types of contract, it's like an infrastructure contract, roads, ports, water, sewage, which is like a government function to be performed. In these kind of contracts, the power of the court to grant injunctions, which mean that restraining the one party at an initial stage itself, that power has been taken away from the courts, which means that the courts can't grant injunction and the performance of the contract should continue. That's what basically section 20A is. And I think it's a very good step, because court at the very initial step may not know the gravity of the injunction which has been granted, and maybe after hearing one party itself, which is called ex parte injunction. So the court are refraining from granting ex parte injunction or injunction at the initial stage. I think that's the purpose of section 20A.
On 22nd December 2017, Union Minister of State for the Law and Justice and the Ministry of Corporate Affairs, P.P. Chaudhary, introduced the Specific Relief Amendment Bill 2017 in the Lok Sabha, which passed it on 15th March 2018. The bill proposes to bring significant amendments to Specific Relief Act 1963.
Now, the Specific Relief Amendment Bill lays a lot of focus on infrastructure projects. Vivek, so what is the bill specifically saying about infrastructure projects?
It is basically the concept of infrastructure is that if a delay happens in an infrastructure project, the loss is much bigger than the which can be
Then the damages.
Can be compensated by the damages, because like if a bridge is not constructed due to breach of a party, then the loss of every commuter is there. So this kind of issues can be tackled if a specific time within the time limit it has to be constructed.
So the bill is basically saying that infrastructure is now going to be a special category.
Special category, and you have to build the project, not just go for the compensation.
Okay. Roshini, do you want to lay down what are those 3 or 4 things that members of parliament should be looking out for and our viewers should be looking out for when they're reading this bill?
Sure. So I just want to mention a few things that the bill does in relation to infrastructure projects. You know, one of the aspects of the act was the fact that there was no differentiation based on the category of contracts. So where there were large public utility contracts or large infrastructure contracts, injunctions could significantly delay the completion of the project. So one of the changes that this bill brings about is to say that when it comes to certain notified categories of infrastructure related projects, the courts cannot grant injunctions, where granting that injunction would mean a delay in the completion of the project. So that's one of the major changes that has been brought about to sort of ease completion of projects. Another aspect of the bill is that it empowers the setting up of special courts to deal with cases that relate to infrastructure related projects. One final thing that I would just like to highlight is the fact that this bill requires the resolution of all matters under this bill to be completed within a period of 12 months. So there is now a time-bound manner in which all cases have to be closed. So these are some of the provisions that will significantly impact infrastructure projects.
Okay. And can the category of these infrastructure projects, can they be increased, can they be decreased, or is it a set category which is already defined in the law?
Sure. So the schedule to the bill has a certain list of infrastructure related projects that relate to transport, water, energy. These can be amended by the government. The schedule can be amended by the government through a notification.
Vivek, let me ask you this. When you look at, these cases in courts, courts have a specific way of looking at a contract. Do courts have the required technical expertise to evaluate as to how do you differentiate between, let's say, a big power project versus a big road project?
Yes.
And what is the kind of help that a court needs?
Sometimes you need the expert opinion in various infrastructure projects. So in this bill, it is introduced that the court can appoint a expert and seek his opinion and take it as
and it's part of the court's record
and evidence they can take in this kind of projects.
Okay. One of the things that was interesting is that the 1963 law originally started its journey, as was shown on the screen, in 1877. So 1877 to 1963, and now 1963 to 2018. Roshini, so what is it that needs to be done when it comes to certain kinds of laws? Do they need to be looked at more periodically, or because such large gaps between review of laws, is that good?
So with the changing economic and legal context, it is imperative that laws are periodically reviewed just to keep updated with the changing environment, the business environment and the legal environment. But while it is important to introduce these bills, it is equally important that there are thorough deliberations in the House of the Parliament, and that parliamentarians discuss the various provisions of the bill, and bills are referred to standing committees for detailed analysis and examination.
Okay. Vivek, what do you think?
Yeah, this process is always on, and many laws are amendment, and recently government has more than 1,000 redundant laws have been abolished. So yes, this process is always on.
Okay. So, let me just get your final thoughts about this bill. Vivek, do you think the bill will help in the ease of doing business ranking, or will it help ease the burden on courts?
Yes, my view is that it is a very good step for a developing nation, and so it will help in overall business sector in India, and overall economic development of the nation, and we will see that in near future we will be the largest economy of the world.
Roshini, very briefly, what are some things that can be taken from this law and possibly used in other laws also, some principles that could work in other laws also?
You know, one of the provisions of the bill is in relation to substituted performance, which is an outside of court remedy, where essentially, you know, if I am to enter into a contract with you for supply of certain goods and you do not supply those goods to me on the appointed date, I can go out and seek performance from a third party. So, you know, this kind of a measure can actually help in resolving cases faster, in completing projects faster, because it is outside of court intervention.
And possibly time-bound,
yes,
closure of cases would also help.
The provision on time-bound completion of cases is also another important provision that can be implemented in other bills as well. And also there are certain special courts designated to deal with infrastructure projects that will exclusively deal with those kind of contracts. So that's another point.
Correct. We're out of time, and thank you, sir, and thank you, Roshini, for joining us on this discussion. It is time for us to end the show. You can watch our shows on RSTV page of YouTube. We will be back with a new issue and a new episode. Keep watching Rajya Sabha TV.